Hello everyone, I'm Ankit and you're watching StudyIQ IAS English channel. Now in our today's video, we'll be talking about the Collegium System of Judiciary. This Collegium System is responsible for appointments of judges to Supreme Court, appointments of judges to High Court and also transfer of judges from one High Court to another. So in our today's discussion, what is Collegium System will be discussed quite in detail. But why are we discussing Collegium System? This is because two articles in yesterday's Indian Express and in today's Indian Express talks about Collegium. If you look at the article on my right, Collegium System has named two High Court Chief Justices and one Judge of High Court to be called as the new judges of Supreme Court in the country. Similarly, this article which appeared today, it said that Collegium System has recommended transfer or repatriation of 21 High Court judges. So automatically you can incur Collegium is a sort of a body which is responsible for appointing members of High Judiciary and transferring the members of High Court. So what is Collegium System? How is that originated in the Indian lexicon? Let us understand this in our today's discussion. But before, let me give you a few details. Now, Supreme Court Collegium yesterday decided to recommend the appointment of the existing Justice of Karnataka High Court, existing Chief Justice of Guwahati High Court and a Judge of Bombay High Court, and they will be the next judges in the apex court of our country, that is Supreme Court. And why are new judges appointed to the apex court? Because obviously vacancies have arisen in Supreme Court after retirement of the former Chief Justice of India, Justice Sanjeev Khanna, and also Justice A S Oka. Similarly, a third vacancy will arise upon quite soon after the retirement of Justice Bela M. Trivedi, right? So, because of these three vacancies, you needed to add newer members to the Supreme Court, and that is why Collegium System has done the needful. Now, the bigger question is, what is the composition of Collegium System? What is the legal authority of Collegium System? All of this I will tell you in our today's discussion. First, let us understand what the Constitution of India says upon appointment of judges to Supreme Court and High Court. First, let us talk about Article 124 of the Indian Constitution. If you read the subsection 2 of the Article 124, it states that every judge of Supreme Court, they shall be appointed by the President of India by warrant under his hand and seal, and this will be done after consultation with such judges of Supreme Court and High Courts in the state as the President may deem necessary. And this subsection also talks about the tenure of office when these judges will retire from office of the Supreme Court Justice, and it says that they will hold the office until he or she attains the age of 65 years, and this means that the tenure of Chief Justice or a Justice in Supreme Court ends when they attain the age of 65. It does not tell how much is the duration when they are required to serve. They can serve n number of years, but they have to retire when they get 65 years old, right? Now, what is the most important part in this subsection is the word consultation, that President can't appoint judges on his or her own. Rather, President needs to consult with the members of Higher Judiciary. Similarly, if you read Article 217 of the Constitution, which talks about appointment of judges to High Court, this also says that every judge of High Court shall also be appointed by President of India by warrant under his hand and seal, but after consultation with the Chief Justice of India, Governor of the state, and in case of appointment of judge other than Chief Justice of a particular High Court, then President also requires to consult Chief Justice of High Court. And the Chief Justice or any judge in High Court, they shall be in the office until they attain the age of 62 years. So, when we were talking about justices of Supreme Court, they will retire at 65 years of age, but a judge in High Court will retire after they attain 62 years of age. Similar to Article 124, it does not say how long can they serve in the High Court. So this means you can serve for n numbers in the High Court, but you have to retire when you attain 62 years of age. Now, the most important part in these two respective articles is the word consultation here, that President can't on their own appoint the judges of High Court and Supreme Court. Rather, they have to consult the members of Judiciary. And this is the word consultation that has created a lot of controversy since 1980s. Let us understand what are the controversy and why it erupted. Now, earlier, since the time Indian Constitution was enacted in 1950, President has appointed the Chief Justice of India and other judges after consulting the Chief Justice of India, which means President of India sought the opinion of Chief Justice of India and made appointments accordingly. But what is a giveaway in this? That as Constitution of India does not say what the word consultation means, so it does not mean that you are bound by aid and advice of judiciary. So a healthy practice had developed between executive and judiciary that President will all the time appoint the senior most Supreme Court judge as the next Chief Justice of India. So whenever the existing Chief Justice of India will retire, the second in command automatically will be elevated to the Chief Justice of India. And this was a convention, a healthy practice that has developed between executive and judiciary. But this convention or healthy practice, it got away when Mrs. Indira Gandhi was the Prime Minister of India, because in 1973 the government of Mrs. Indira Gandhi, they overlooked the three senior most judges in the Supreme Court, and rather they appointed the fourth most senior judge in the Supreme Court, then Justice A. Ray, as the next Chief Justice of India. And this was 1973, when the healthy convention that existed since 1950 got broken off for the first time. Here Justice A. Ray, who then was the fourth most senior judge in the Supreme Court, he was appointed as the Chief Justice of India, and this even continued after retirement of Justice A.N. Ray as then Chief Justice of India. Afterwards, after retirement of Justice A.N. Ray, Justice Khanna was the most senior most judge. So naturally he could have been appointed as the next Chief Justice of India, but no. Indira Gandhi government in 1977, they appointed Justice Beg as the next Chief Justice of India, who was second in command, not the senior most judge in the Supreme Court. So that is why this earlier practice, a healthy convention that existed since 1950, it got broken off first in 1973 and then it got broken off in 1977 after government overlooked the senior most judge and not appointed them as the Chief Justice of India. So this healthy understanding between executive and judiciary, it got broken off, and naturally this created controversy of whether or not the opinion of judiciary, opinion of Chief Justice of India, is it bound on the executive or not. And when this matter got a big matter, it led to many cases filed in the Supreme Court, and Supreme Court, since by giving many judgments, has defined what is the word consultation, and accordingly it has also determined what is a collegium system. Let us understand this by understanding these cases one by one. First important case in this regard, which is the case of S.P. Gupta versus Union of India case, more popularly known as First Judge's case. This judgment was given by Supreme Court in the year 1981. And in this judgment, Supreme Court said that the word consultation, given in Article 124, given in Article 217, it does not mean that government is required to follow the advice given by Chief Justice of India. Hence, the advice given by Chief Justice of India is not binding on the government. So from this First Judge's case, what we can infer, that the word consultation, which is given in the Constitution of India, it does not mean concurrence or legally bound advice of the judiciary. So this was the matter that settled the case in the ball of executive's court, which means executive, it was the prerogative of executive to seek opinions of Chief Justice of India and higher judiciary, but they were not bound by the advice given by higher judiciary, right? So this was First Judge's case. Similarly, this issue was not settled and ultimately it also reached Supreme Court in 1993, and here Supreme Court of India gave a judgment in the case of Advocates on Record Association versus Union of India case, which is more popularly known as Second Judge's case, and this judgment was given in 1993. Here Supreme Court actually overturned its judgment given in First Judge's case. In Second Judge's case, Supreme Court of India said that the word consultation, it meant concurrence with the advice advice given by judiciary, which means whatever advice Chief Justice gives in this regard is binding on the government. And this judgment also said that here the just advice of Chief Justice of India alone wouldn't suffice. Rather, Chief Justice, before sending this advice to President of India to make appointments, he or she shall also consult other senior judges of the Supreme Court. So effectively, what the second judge's case did, that the word consultation in the Constitution of India, it actually meant concurrence with the opinion of judiciary, which means executive is legally bound to follow the advice given by the judiciary, which is an advice given by Chief Justice of India and two senior most judges of Supreme Court. So this was the first time the collegium system emerged, and this emerged out of a judgment given by Supreme Court. So what was the size of collegium system after second judge's case? It was Chief Justice and two senior most judges of the Supreme Court. So this was the first time when collegium system appeared. Similarly, this dispute persisted in the court of law, and in 1998 the Supreme Court of India gave its judgment called as third judge's cases. And here the Supreme Court of India actually did not overturn the 1993 judgment. It said the advice given by Chief Justice of India and other senior judges of Supreme Court is bound on the government. That means consultation means concurrence, but for appointment of judges to Supreme Court, the advice given by judiciary will be given by Chief Justice of India and four senior most judges of Supreme Court. Similarly, for High Court, the advice given by Chief Justice of India will include Chief Justice of India, two senior most judges of Supreme Court, and they will also consult any other Supreme Court judge who has served in that particular High Court where the appointment needs to be made, right? So this judgment actually, it enlarged the size of collegium system, that is for appointments to judges of Supreme Court. Here the advice will be given by Chief Justice of India and four senior most judges of Supreme Court. Similarly, when you have to appoint a judge to High Court, here the advice will be given by Chief Justice of India, two senior most judges of Supreme Court, and other judges of Supreme Court who have served in this particular High Court before. So effectively, this was the size of collegium system after the end of third judge's cases in 1998, right? Now this was the collegium system I told you. Now this appointment to the members of higher judiciary, you can understand, although it is made by President of India, but President of India is bound by the aid and advice of the collegium. So this means independence of judiciary is maintained. Judiciary is solely responsible to who to appoint in Supreme Court, who to appoint in High Court, and who to transfer from one High Court to another. Now government did not like this system. So what government did in 2015, when the new government of NDA had come only a year prior, the government of India brought 99th Amendment Act to the Indian Constitution. And this 99th Amendment Act of Indian Constitution, it provided for a new system for appointment in the judiciary, and this system was called as a National Judiciary Appointment Commission, NJAC. And you know who will be the members of NJAC? These will be one Chief Justice of India, two senior most judges of Supreme Court, law minister in union government, and two eminent personalities who will be appointed by a committee comprising of Chief Justice of India, Prime Minister of India, and leader of opposition in the Lok Sabha. So effectively you can see this NJAC ultimately changed the system of appointment in the judiciary. Earlier in the collegium system, only the justices were responsible for sending the advice to president, which by the way was bound on the president. Now this will be recommended by a committee of members which included Chief Justice of India and two senior judges of Supreme Court. So effectively 3 members from judiciary and 1 member from government and 2 eminent personalities. Eminent personalities also were not the member of judiciary. Now, judiciary did not like this NJC system. It felt that when you were allowing other members, not the part of judiciary, to decide who to appoint in the judiciary, this actually went against the tenet of independence of judiciary. And according to Supreme Court of India, independence of judiciary is a basic structure of constitution which a parliament can't change, and accordingly Supreme Court of India held that 99th Amendment Act was unconstitutional and void. So basically, after 99th Amendment Act was declared as unconstitutional and void, so the system of appointment reverted back to the collegium system. And even till today, this collegium system, which emerged after the third judge's case, that is, this composition exists even till today. So the appointments that were made in the articles that I have shown you were made by this very collegium system only, and not by NJAC, which was declared as unconstitutional and void in 2015. Understood? Any doubts? Now, before ending this session, I would like you all to solve this particular question, and do let me know the correct answer of this question in the comment section. And if you want to download the notes, these notes will be available on my Telegram channel. This Telegram channel is called as ATS Live. So what you can do is search the words ATS Live on the Telegram app in the top right hand corner in the search bar. Also, you can scan this QR code. This will take you definitely to my channel. Subscribe to the channel if you still haven't, and do not forget to download the notes. And also, answer the correct answers in the comment section. If you answer it correctly, I will give your comment a like. You will understand you have gotten this right? So this is all from my side for today. I will see you again tomorrow. Please have a very good night.